Good afternoon, ladies and gentlemen. My name is Tommy DeMisa, and this is a webinar installment from the Nonprofit Resource Hub. I want to just give everybody about 30 seconds to kind of get situated, and then I'll be going into some background on the Nonprofit Resource Hub, and we'll tell you specifically about our speaker today. So first, what I want to just kind of give you a run of show. I'm going to do a quick introduction, and then for about 40 minutes, our speaker, David Goldstein, will be taking us through our material today. Right around the 12:40 p.m. hour, we will have an opportunity for any questions and answers that David may be able to provide to those questions you have. So just kind of, you can put some questions in the chat, or you can use the Q&A button on the bottom of your screen, or you can hold those questions to the end and we can get those later in the program. So at this point, it's 12:01. I am going to get us started. So just from a logistics perspective, this is structured as a webinar. So you will not see yourself on the screen. Don't be concerned. That's how it's set up. And utilize the chat function and the question and answer function as I've mentioned so far. So to get us started, first I'd like to say good afternoon. Thanks very much for attending our event. As I mentioned earlier, my name is Tommy DeMisa. I am with the Vanguard Insurance Agency. We're an employee benefits firm, and we are one of the founding member companies of the Nonprofit Resource Hub, or as we affectionately call ourselves, NRH. So NRH, or the Nonprofit Resource Hub, is a trade association whose mission it is to serve, be a resource to educate and connect its members in the nonprofit community. At the same time, the NRH serves as a nonprofit sector bridge connecting nonprofit organizations to resources, as well as other nonprofit organizations that may be potential collaborative partners for those organizations. We share a directory of vetted and trusted organizations and professional solution providers that provide high quality products, services, and education with a specific niche focus on the sector. And we are continuously adding to this roster of what we call associate members. So we're always looking for what I call best in breed to bring and deliver to the sector. These organizations that are associate members, they go through a rigorous process where we vet out their quality of work, the service they provide, and also their commitment to the nonprofit sector. The NRH is also responsible for hosting networking events and also foster opportunities for collaboration, both with like-minded nonprofit professionals as well as leaders in the for-profit sector, as I discussed there. We also provide information and insight to the sector to keep them informed about key issues and resources that exist within the sector. We offer expert advice and consultation to the sector to help organizations effectively further their missions. And we also serve as a one-stop resource for nonprofits, providing a single access point for information. So the Nonprofit Resource Hub came out of the brainchild of 5 different organizations: Nonprofit Sector Strategies, Serini and Associates, CPA firm, Certilman Balin Attorneys, Triumph International Consulting, International Business Consulting, and the Vanguard Insurance Agency, as I mentioned, which is our firm. Our new website is up and running, and you can access that website, which one of my partners is probably putting in the chat, but nonprofitresourcehub.org. I see some of the stuff going on in their chat, so feel free to check it out. As a member on the nonprofit side, as a nonprofit member, you get the opportunity and ability to share your events on our calendar, which can be reviewed by other nonprofit organizations or people that might be interested in connecting with you, learning more about your mission, learning more about your programs. On the website, you'll also see that there are articles and white papers by both our founding members as well as the associate members. And once you join, there's other benefits that you can take advantage of, as far as you'll be listed on the site with your logo, your mission, and a link to your website. And there is no cost for being a member of the Nonprofit Resource Hub as a nonprofit member, that is. We right now, we started this quick raffle from November 18th of this year, which will be ending on the 31st. We will be randomly selecting any new nonprofit partners that join the hub from the 18th up until the 31st of this year. And we'll be giving out randomly 5 $200 donations to those organizations. So certainly take advantage of that. I wanted to send some gratitude out to our associate members that are currently on our roster, as I say. From the staffing perspective, Gail Brandell and her firm PNP Staffing on the payroll and HR solution side, Mike D'Onofrio of Premier Payroll, Darren Port, Powered by Professionals, handles our fundraising category and had a great webinar a couple weeks back. Noel Robb and his firm 5-Star Advertising. In the advertising space, Matt Thompson of Morgan Stanley as an investment advisor with a major focus on serving the sector. Michael Fleischer of Sterling Risk on the property and casualty insurance space. James McTighe of Lee, Nolan, and Coreglian, which is a life insurance firm focused on the sector, as well as Doug Rowe, a partner over at Certilman Balin, who handles human resource law as well as employment law, and Eleanor Ellie Hume, which is at least part of your part-time controller, which is outsourced CFO advisory type services for the nonprofit hub and for our members. So that sort of kind of lays out who we are and what we do. At this point, what I'm going to do is I'm going to just quickly read a bio of our speaker of the day. David Goldstein is the founder and chair of the nonprofit tax-exempt religious organization practice group at Certilman Balin. He represents international, national, regional, and local not-for-profit organizations and religious entities across a wide variety of the nonprofit sector. He serves on the executive committee for the New York State Bar Association's Business Law section and is the chairperson for the Nonprofits Corporations Law Committee of the State Bar Association's Business Law section. So, ladies and gentlemen, without further ado, I'm going to pass the microphone over to David Goldstein. David, thank you very much for being here. Take it away, please.
Thanks very much, Tommy. Appreciate that. Welcome, everyone. Glad you could join us. I'm going to share my screen and we'll be ready to go. Okay, good. So our topic today is nonprofit governance, what your board needs to know. And I'm going to apologize in advance. We've got a lot to cover, so I'm going to speak kind of quickly, but I want to invite you. My contact information is at the beginning of the PowerPoint. Feel free to call or email if you have any questions. If I went too fast and you didn't understand something that we were talking about, please reach out to me. Happy to go through it with you offline. So lawyers like to start with hypotheticals, and I was going to do that, and then I decided that I would start with something that isn't hypothetical. It's an actual scenario. It's a little on the sobering side, both in terms of content and in terms of outcome, but I think it's important to ground us a little bit. In early May 2020, while New York was the epicenter of the international coronavirus pandemic, a client of mine, a New York cemetery corporation, called with a problem. Cemeteries are, for the most part, required to be nonprofits under New York law. A lot of people don't realize that. There are all sorts of different nonprofits. There are the charitable nonprofits that we're all aware of, but then there are trade associations, there are cemeteries, and lots of others. And so, in addition to being governed by the rest of the nonprofit law, there's a separate article of the NPCL, not-for-profit corporation law, that covers public cemetery corporations. A cemetery corporation is a charitable nonprofit and is governed by all of the provisions of the law that would relate to other charitable nonprofits. And they function as membership corporations, with the lot owners having the role that voting members would have in other nonprofits. In addition to the certificate of incorporation requirements that apply to other nonprofits under Section 402 of the law, under Section 1505, there are specific requirements that apply to cemetery corporations, including that cemetery corporations have to specify the date of their required annual meeting in their certificate of incorporation. So some of you probably can see where this is going, given that this phone call came in May. The superintendent of the cemetery corporation, who is the equivalent of an executive director in a standard nonprofit, called up and said, our certificate of incorporation requires that our annual meeting be held every year in early June. My staff is overwhelmed. We can't keep pace with the need for cremations as well as burials. My staff is terrified to come to work every day. We have refrigerated trucks with bodies lined up outside the cemetery. I can't sleep at night. I don't know how we're going to manage. We can't keep up. I can't devote the time or the mental energy to holding an annual meeting of lot owners. We need to postpone the annual meeting. So here we've got a nonprofit governance problem with very, very real world impact and implications. So I told the cemetery superintendent about the governor's then recent executive order that made a limited pandemic-related exception to the law to allow annual meetings of members to be held remotely or by electronic means. And that would be including the ubiquitous Zoom conference. Before this exception, member meetings could only be held in person, but keep in mind that board meetings could always be held by phone or video conference. That's going to be relevant to something we talk about later. So if I want to be invited back to give future nonprofit resource hub webinars, I can't repeat what the superintendent said to me in my in response to my suggestion that he consider a virtual meeting of his members. Under the dire circumstances that prevailed, even a lot owner's meeting via Zoom was way too much for him to pull off. Preparing for, organizing, and running a meeting like this in the midst of this calamity was just inconceivable for him. We reached out to the New York State Division of Cemeteries, which is part of the Department of State, and they confirmed that there was no special dispensation available that would authorize the postponement of the cemetery's annual meeting. Notwithstanding the mandatory legal requirement at play, notwithstanding the breach of fiduciary duty by each member of the board of directors that not holding the annual meeting when required would entail, the cemetery decided to postpone its annual meeting. So with that unfulfilling and depressing real-world scenario as our jumping off point, let's explore some of the basics of nonprofit governance. We'll start with the impact of the pandemic on nonprofit governance. We'll talk about what has changed permanently and what has been adjusted temporarily. Then we'll expand our focus and pan out to some fundamental aspects of nonprofit governance and some traps for the unwary that are really important for you to know. So what has changed permanently as a result of the pandemic? This is going to be a fairly brief slide coming up. And the answer is nothing. There have been no permanent changes in the law resulting from the pandemic. What has been adjusted temporarily? So here we have three types of legal and regulatory relief during the pandemic: governor's executive orders, a bill enacted by the legislature, and the Attorney General's Charities Bureau guidance. So in April, the governor released an executive order that modified, during the state disaster emergency, one section of the law to the extent necessary, and the highlighting is there so we can see how narrow this is, to permit annual meetings of members to be held remotely or by electronic means. So this only applied to members, only applied to members' meetings, only to annual meetings of members, and only during the state disaster emergency, which is still ongoing, by the way. So we see here that the first action by New York State in the realm of nonprofit governance related to annual meetings of members. And this highlights the importance of members' rights in the governance scheme. In particular, the annual meeting, and we're going to come back to that later as it relates to board-only nonprofits, but the annual meeting of members is the fundamental nonprofit governance event. Two things have to happen by law. More things can be added to the agenda, but a minimum of two things must occur at the annual meeting: election of directors and the delivery of the annual financial report. More about that later. So this executive order temporarily allowed participation by video conference or conference call in member meetings. Without this temporary modification of the law, and once this temporary modification is no longer in effect, annual meetings of members, remember we're only talking about members now, need to be held at a place, that's the term used in the law, basically in person at a physical location, and without participation by video conference or conference call. So that the membership meeting concept is a very sort of 20th century uh, uh, democratic participation type concept where everyone gets together at a physical place for the membership meeting. So what about non-member nonprofits? Basically board-only nonprofits. And I suspect that a lot of you on the call who are board members or senior staff people of nonprofits are involved with board-only non-member nonprofits. Here too, in nonprofit governance law, we see the primacy of the annual meeting, which is the fundamental nonprofit governance event, even for a board-only nonprofit. And the same two things are required to happen in a board annual meeting as would happen in a membership annual meeting: election of directors and the delivery of the annual financial report. No exceptions. That has to happen every year at every annual meeting. Participation by video conference and conference call are always permissible in a board-only nonprofit as long as they are not prohibited by your bylaws or certificate of incorporation. On June 17th, Governor Cuomo signed Bill number S-8412 into law. It was effective immediately, and it provided for the duration of the state disaster emergency, the board may determine that meetings of members, and this is what we're talking about now, is actually the only legislation in the nonprofit governance realm that was enacted during the pandemic. And again, here, that's what the yellow highlighting is about. We're only talking about members' meetings. The board may determine that meetings of members be held partially or solely by means of electronic communication. This is effective for the duration of the state disaster emergency and until December 31st, 2021 at the latest. It includes both annual meetings and special meetings. There's some more meat to the bones here compared to the prior executive order, which was superseded by this legislation. This statute provides that the board has to implement reasonable measures to verify that each person participating electronically is a member or a proxy of a member. Pretty straightforward. Provide that each member participating electronically has a reasonable opportunity to participate in the meeting, including an opportunity to propose, object to, and vote upon a specific action to be taken by the members, and to see, read, or hear the proceedings of the meeting substantially concurrently with those proceedings. That goes to that same core corporate democracy process. And finally, the board needs to have reasonable measures in place to record and maintain a record of any votes or other actions taken by electronic communications at the meeting. Just by way of a side note, we're not going to delve into this on this webinar, but a similar provision allowing membership meetings by electronic communication, although there are some important technical distinctions, this was also added to the Religious Corporations Law, again, with some technical distinctions that are important. That's actually a very critical provision because the need for membership approvals arises more frequently under the Religious Corporations Law, and so this was very important relief. Okay, back to nonprofits. So what have we seen so far? Both the governor's executive orders and the state legislature's pandemic enactment address only membership meetings. In April 2020, there was guidance issued by the Attorney General's Charities Bureau, and it's entitled Guidance for Conducting Virtual Meetings of Members of New York Not-for-Profit Corporations. By the way, this is a good point at which I could segue to mention that you've got supplementary materials that we sent a link for, and these include the bill signed in June, amending the Not-for-Profit Corporation Law and the Religious Corporations Law. They include this guidance and some additional very important Attorney General's guidance, and also a bunch of other things that hopefully we'll have time to get into a little bit before we're done. So here too, this Attorney General's guidance applies only to member meetings. The main import of this Charities Bureau guidance is that it gives us some detailed input on how to conduct a member meeting via video conference. And I'm going to get into that, but I just want you to keep in mind that we're going to come back to this because this is also going to be relevant for board meetings, and we'll get to that in a couple of minutes. So what does the guidance provide? It says that the board should make sure that the members, in addition to the video conference option, have an option to dial in only. That's something that, of course, is standard for Zoom meetings and is very important and highlighted in the Attorney General's guidance. The Attorney General suggests that that the nonprofit test the system in advance of the meeting, make sure that it's going to come off without a hitch, assure the ability of attendees to participate, and appoint someone to assist members having trouble joining the meeting in real time. This is a really important and very intuitive suggestion. Basically, it would require you to disseminate the phone number in advance of a person who's there, who can walk anyone having technical difficulties through either joining the video conference or dialing in. The guidance highlights the importance of proper notice of the meeting, documenting and keeping an eye on attendance and quorum at the meeting, voting requirements applicable to the meeting, and proper minutes of the meeting. And this is going to come up, I think, a couple of times before we're done today, but you can do everything perfectly from a governance perspective, and if you blow it at the final step, which is the minutes, then it's almost as if it never happened, because 3 or 4 years from now, without minutes that document what you did, it's going to be very difficult to establish that you hit all the various bells and whistles that you're required to hit. So what does all of this information and guidance about membership meetings tell us about board meetings? If you're on a nonprofit board or if you work for one, you know that board meetings via video conference have become ubiquitous during the pandemic. But there are no executive orders, legislation, or guidance issued that directly relate to board meetings. First thing that tells us is that the laws and procedural requirements regarding board meetings have not changed, not one iota, during or as a result of the pandemic. That being said, board meetings require incredibly careful attention to requirements for notice, requirements for quorum, which is the minimum number of directors you need to be present to validly conduct business, and that's generally set forth in your bylaws. If not, there are provisions of the statute that would govern. So it's vital to be apprised of the quorum requirement applicable to your meetings, because if you don't have a quorum, you don't have a meeting. You can't act validly. Voting requirements are very important to keep an eye on. It's important to note that for board meetings, there are likely going to be relevant voting requirements outlined in your bylaws, maybe also in your certificate of incorporation. And for sure, there are mandatory voting requirements throughout the not-for-profit corporation law, including what are referred to as supermajority requirements. Certain decisions by the board, certain actions require more than a simple majority. And it's vital to understand what those are, because again, if you don't have the requisite supermajority approval, then the action is not approved. One thing that is applicable to every board meeting, and it's the fundamental aspect of nonprofit governance from the board perspective, is that the board has oversight responsibility. And again, I hope we'll have some time to talk in more detail about that, because oversight is a concept and a word and a process that before, during, and after every board meeting is something that really needs to be in your focus and front and center. A little footnote with respect to board meetings, it's a little confusing for people. You sometimes hear about the use of proxies in the nonprofit membership context, and Again, the law permits that as long as it's not prohibited by your bylaws. But that's only for members and membership meetings and membership voting. Directors can never give a proxy to anybody else. And that's really important because very often you see boards confused and proxies being given to other directors or to other individuals. And that is always impermissible. Proxies can never be used in the nonprofit board context. So let's see. Okay, so in the board context, participation by video conference and conference call are always permissible as long as they're not prohibited by your bylaws or certificate of incorporation. The recent Legislation and Charities Bureau guidance, while aimed at membership meetings, can provide incredibly useful best practices for board meetings. So they're not mandatory, but really they've become a roadmap to best practices for a board meeting and for video conference and remote participation. So one of the items that are in the Attorney General's guidance and should be in place for every board meeting is the option to dial into the video conference in addition to the video participation. And this is a wonderful practical safety net. I was on a board meeting a few months ago and the power went out in certain parts of Long Island. So I lost power and so did a few other board members. And because there was a dial-in number, we were able to dial into the call, even though our routers were down and we couldn't participate by video conference, and the board call was able to continue. And there are lots of other advantages to the dial-in option. It generally boosts participation if someone's not feeling well, or in transit in their car, or not feeling particularly video conference ready at that point in time. It facilitates their participation. So that's an important practice, an important best practice. Also, appointing someone to assist board members having trouble in real time and disseminating that phone number in advance in the meeting notice, very easy to do and very valuable in a pinch. In general, as we discussed with respect to membership meetings, attention to notice, attendance, quorum, voting, and after the meeting minutes is critical. And of course, providing each board member participating electronically with a reasonable opportunity to participate in the meeting, including an opportunity to propose, object to, vote upon a specific action to be taken by the board, and to see, read, or hear the proceedings of the meeting simultaneously. That may seem like it goes without saying, but sometimes it doesn't happen. So that's an important element to keep in mind for all board meetings via video conference. So none of this is particularly complicated or rocket science, but and therein, and if you've met me before, you're familiar with my mantra that nonprofit governance is not rocket science. But as you can see, it's very detailed, very process oriented, and requires a commitment and discipline to implementing proper nonprofit governance. So as we said, some of these membership concepts and laws and guidance are very useful for board meetings. I'm going to slide past this this slide and so that we can go a little further into the outline before we run out of time. I'm going to pan out now from governance mechanics to the big picture, and we started with a non-hypothetical, the Cemetery Corporation's annual meeting, and albeit an extreme fact pattern, it's a real one. We need to keep in mind that it's not only cemeteries that are facing tremendous stress during the pandemic and dealing with these challenges. Many nonprofits that deliver essential services, for instance, soup kitchens and food banks, are faced with really daunting challenges. Revenues have decreased. Fundraising events that have long been relied on can no longer be held in person. There's the prospect of decreased government funding. And when you couple that with the increased need that the recipients of services have as a result of the pandemic, decreased revenues and insufficient reserves to fill the void, it's quite a problem. Then when you layer that on top of some of the other practical problems that nonprofits are facing, for instance, a soup kitchen would have the need during the pandemic to rework food production and food delivery. They've got to do that on the fly. That can be a costly process. And then, of course, they've got all the issues with staffing and workplace safety that other organizations have, but they don't have the flexibility of working from home because of the essential in-person services they deliver. And these types of challenges and the effects of the pandemic ripple across every nonprofit, from soup kitchens and food pantries to youth sports leagues that basically have had their schedules and activities in most instances completely eliminated. So what we also see, unfortunately, is that these nonprofit governance issues that all nonprofits are facing sometimes occur on a platform of existing internal dissension and disputes in a nonprofit. And then you've really got a hypercharged environment. You've got hostile factions in a nonprofit and percolating internal disputes and maybe even complaints or investigations to regulatory authorities. And so now you've got all of these pandemic challenges, potential delays in elections of directors, which are required, in financial reporting, which is required. Some nonprofits even have expanded reporting above and beyond what's in the law. Their bylaws require even more detailed reporting at the annual meeting. And so when that's delayed by the impact of the pandemic, you've got delayed transparency and accountability, and that interacts with the friction in nonprofits where there's already tension, and so now you've got allegations of violation of fiduciary duties because the board has a legal duty to have elections, to provide financial accountability, and as we've seen, there's absolutely no basis for significant delay. There's been no dispensation granted, no exceptions made, other than the very limited exception for remote member participation in member meetings. So I'm gonna hit some actual questions posed to me during the pandemic, and we'll get some sense of how real life interacts with the nonprofit governance environment during the challenging times that we're living in. So in May, at the height of the pandemic, had a client that had a board member in the hospital with coronavirus, and he gave another board member his proxy. We've already seen, absolutely impermissible. You cannot do that. Another instance where two board members were sick and unable to participate in the meeting, the board chair sent an email to the board suspending the quorum requirement for the next meeting, again, due to the fact that two directors were ill with COVID-19, but again, absolutely impermissible under the law. At the board meeting, the board voted to suspend the applicability of the bylaws for just this meeting due to the pandemic. Again, no special exceptions, and that was an impermissible action by the board. Another client said that the board had decided to skip their annual meeting for 2020 and to do a combined 2020 and 2021 annual meeting early in 21. Again, as you've seen, what they heard from me was, no, you can't do that. And so, in fact, they held their meeting in 2020, and they did it remotely, and so they were in compliance with their requirements under the statute. Another nonprofit was planning to have their annual meeting, elect directors to the board as required, but not to deliver the annual financial report because the pandemic interfered with the necessary preparatory process. Again, doesn't work. No exception for delayed delivery of the required financial information. We're going to have our annual meeting, elect directors to the board, present the annual financial report as required by the not-for-profit corporation law, but we are not going to deliver the additional reporting as required by our bylaws. Here too, everyone on the board has a fiduciary duty, a legal responsibility to follow the requirements of the bylaws and And so there's no ability to waive that, pandemic or otherwise. So here's another actual question posed by a board. This board was very large, and decorum for video conference board meetings was challenging. There was always lots of background noise, and the board members, in spite of repeated requests, weren't properly muting themselves. So the ED and the board chair came up with the following plan, which was to keep everyone muted but the board chair and anyone at that point who was presenting a report to the board. And the others on the board would be unmuted for board votes, but at no other time. And there too, that kind of process violates the required democratic deliberation that's necessary for board meetings. So also a practical solution that is not permissible. So something else that we've seen so far is the primacy of the annual meeting as the fundamental nonprofit governance event. It's mandatory and has the two mandatory components: election of directors, delivery of annual financial report that we discussed. There's some traps for the unwary here that I want to hit on. And one involves the annual financial report mandated by the law, which requires specific information be included. There's a little bit of a timing trap there that I want to make everybody aware of because it's easy to miss. The annual financial report mandates, the requirement mandates that the financial information be presented for a 12-month fiscal period. Makes sense, it's an annual report, terminating not more than 6 months prior to the date of the meeting. So if your fiscal year is the calendar year, then for your financial information not to be stale, you need to have your annual meeting and present the annual financial report before the end of June. Because of this rule, June tends to be my busiest month of the year, as many of my clients schedule their annual meeting in June to maximize the amount of time that their accountant has to prepare the financial data, but still meet the not older than 6-month requirement in the law. So here's another trap for the unwary that that is related to our current environment. Executive directors and board chairs tell me that their inclination is to cut back on the amount of information flowing to directors and the length of meetings. Again, that's a natural inclination because a lot of people have the sense that while there are some advantages to a video conference, one of the disadvantages is that a lengthy meeting is somewhat more difficult and unmanageable than a lengthy meeting in person. So too much information and meetings that are too long are a little harder to tolerate in a video format. There too, that's an understandable adjustment, but it's a very dangerous dynamic because it's an axiom in the nonprofit governance realm that timely and adequate flow of information to the board is required for the board's mandatory oversight function. You remember that I mentioned earlier how critical oversight was and that it always needs to be in focus. And so this is one of the areas where you need to be very careful that by cutting back the length of meetings and the amount of information, you're not impeding the necessary oversight that the board is required to implement. Doing so would have an unintended consequence. It would open the board up to a breach of fiduciary duty claim because the absence of adequate oversight is a breach of the board's fiduciary duty and opens the board members up to personal liability under the provisions of the not-for-profit corporation law. And that's a nice segue, and we have a few minutes left, so I'm going to try to speed through some of this. But that last slide is a nice segue to the fiduciary duties of nonprofit directors. And there are two fundamental precepts, which we just hit on, which is first and foremost that directors of nonprofits have legal duties under the law, referred to as fiduciary duties, and that the law provides that there can be personal liability to directors for breaching these legal duties. And that puts some teeth into some of these process requirements that we've been talking about, there can be very real-world consequences when the proper process is not followed. The three fundamental legal duties of a nonprofit director under New York law are the duty of care, the duty of loyalty, and the duty of obedience. And you've got some very good information on those in your supplementary materials, a little bit of a tongue twister. And in particular, the Attorney General guidance publication, which is document 4, entitled Right from the Start, focuses on the fiduciary duties of nonprofit directors. It's written for non-lawyers, so I really commend that to your reading. It's short and incredibly helpful. So quickly, we'll touch on the duty of care. This duty is, in fact, laid out explicitly in Section 717A of the law, and it requires a director to discharge the duties of his or her position in good faith and with the care an ordinarily prudent person in a like position would exercise under similar circumstances. That's a mouthful, but you can boil it down to one word: oversight. It's the oversight function that we were talking about. But again, there's a diligence required to exercise that oversight. It's not the level of oversight that is convenient for me at the time. It's the level of oversight that an ordinarily prudent person in like position would exercise under similar circumstances. So to do that, you're going to have to be familiar with the organization's finances and activities and regularly participate in the organization's governance. And if you look at, again, it's a very short document. It's item 5 in your document list. It's a summons in a 2016 New York Supreme Court case, the Healing Arts Initiative lawsuit. And there, everyone on the board was sued for breach of this fiduciary duty. And the basis of that suit was very simple. They dropped the ball. They failed to exercise the oversight that the law requires, and they were sued. And the summons was looking for damages and in addition, legal fees and punitive damages. So that's something to look at, and it's a very nice and succinct statement of the oversight requirement. So directors are always asking me, well, okay, we understand we have this duty of care. Give us a roadmap as to how we can comply with the duty of care and protect ourselves from breach of fiduciary duty claims. And so these documents here and these concepts and a lot of what's in your supplementary materials are designed to give you that roadmap. First and foremost, right from the start, the guidance document I mentioned. You've got a lengthy case in your materials, and it's from 1997. You also have a more recent case, which we'll get to in a minute. The reason it's so useful is it's very detailed, the Adelphi case, in the exploration of what was facing the board and how the board behaved and how they should have behaved, what they did wrong, what they should have done differently, and what resulted in the board having liability for breach of duty, and also being removed from office as a result of this decision. So it's actually a very detailed and helpful exposition and worth your read. Next, and that's a decision in the Adelphi matter. Next is a complaint that was filed in 2019 in connection with the Dowling College bankruptcy, where all of the board members were sued for breach of fiduciary duty, as well as the CFO. And here too, it's very detailed and goes into blow by blow of what the directors did wrong in their oversight and their lack thereof in allowing the bankruptcy of Dowling and allowing the insolvency to unfold. And in particular, there's a focus on the requirement, and this is critical to oversight. The board has an affirmative requirement to exercise adequate oversight, and in doing so, an affirmative requirement to receive adequate information. So it's not possible for the board to say, well, we didn't exercise adequate oversight because we didn't have the information. The board has an affirmative obligation to insist on receiving that information in sufficient detail and in a timely nature so that they can exercise oversight. That is critical and somewhat surprising sometimes to nonprofit directors. So it's not enough to be a passive recipient, and that was really what the allegations were in the Dowling complaint, that the board was a passive recipient of information which was not flowing in a timely fashion or in a sufficient fashion or in an accurate fashion, and therefore it was impossible for the board to exercise adequate oversight, which was the proximate cause of the nonprofit's demise. So that aspect of nonprofit governance, information flow, is critical. Internal controls are critical, and there's a very helpful guidance document in your materials from the Charities Bureau on internal controls. It also touches on policies and procedures. And a subject for another day is the critical role of audit oversight. And just for you to have a sense of how critical that is, there's only one committee in nonprofit governance that has a dedicated section, a section of the not-for-profit corporation law that solely relates to that committee, and that is the audit committee. And that highlights how important the legislature and the attorney general feel the role of the audit committee is in nonprofit oversight. So I'm gonna slide through very quickly. Duty of loyalty is something that's self-explanatory, but what I want to stress there is that New York has the most demanding conflict of interest and related party transaction requirements in the country, and that is how we most often see the duty of loyalty impact nonprofit directors, nonprofit governance, and these provisions with respect to conflicts of interest and related party transactions apply not only to board members, but to officers and key persons, which are defined in the law. The duty of obedience, and I want to make sure to get this in under the wire time-wise. This is the least understood and most often neglected of the three primary legal duties. The reason for that is the other two, duty of care and the duty of loyalty, exist in the for-profit world. The duty of obedience is strictly a not-for-profit law concept. What is it? It's to ensure that the organization complies with applicable laws and regulations and its internal governance documents. And when you stop for a minute and think about it, that's an incredibly far-reaching fiduciary duty to impose on every director and every officer. Compliance with applicable laws is incredibly broad and burdensome. There are multiple layers of laws and regulations. Obviously, the not-for-profit corporation law front and center, but there's way more. There are other state, federal and local laws, and one example is in the realm of lobbying. There are federal requirements that apply to tax-exempt organizations. There's a state lobbying law, and there are local lobbying laws. So duty of obedience on the compliance of law with law side is quite the handful for boards. And we've seen that with respect to the not-for-profit corporation law, it is not best efforts under difficult circumstances. That is not the standard. It's a law. It has mandatory requirements and mandatory procedures. There are bright lines. They're rigid, inflexible, unforgiving, no compromises, no exceptions. The duty of obedience also has, and I'm going to end on this concept, the other component of the duty of obedience is compliance with internal governance documents and policies, and that is primarily the two that we see coming up all the time are the certificate of incorporation and your bylaws, and there are multiple traps for the unwary with respect to both the certificate of incorporation and bylaws, and I think that when we do part two of this presentation, I'm going to pick up and start with the traps for the unwary that are hidden in both the certificate of incorporation and the bylaws. And with that, I want to leave some time to the extent that anybody has any questions. I'm gonna look, and I don't see any questions in the question tab. Um, and I'm going to let Tommy or Ed jump in. I don't know if anyone's emailed any questions to either of you. Happy to entertain questions now, or again, offline if anybody has them. Thanks for your attention. I think we're pretty much on time. You can feel free to thumb through the rest of the slides if you have questions on them. Stay tuned for us to schedule part 2. And also in the interim, feel free to give me a call if something comes up. Ed?
Yes, David, thank you. I'm just looking in the chat quickly. I too do not see any additional questions, but if any pops up as over the next 2 minutes, we'll jump in with those. So thanks again, David. As always, David is incredibly informative for nonprofits, and I know that this was probably a wealth of information for everybody. So thanks again, David. I do want to remind everyone, and I want to first thank everybody for attending our webinar today, and to look out for our webinars that are coming up in the future. Yes, I do see that we are being asked a lot if this was recorded. It is recorded, and I believe it will be shared. So look out for that. And that leads me into the next thing I wanted to state. We are going to be sending out a survey, and we'd appreciate if you could send back those surveys and respond to them. We'd really like to know what you think about our events. If there's anything that you additional you'd like to see in the future, or anything you'd like to see changed about the way we present our events or the contents, please, we want as much feedback from all of you as possible. These events are designed to provide resources and education for all of you, so your input is very appreciated. With that, I also want to mention, please check out our website if you haven't done it already. It's at the Nonprofit Resource Hub, not the nonprofit, www.nonprofitresourcehub.org. On that site, you can view much of the content. This recording will be up on that site as well as our past webinars, and a whole myriad of content that is being produced regularly, similar to what you heard from David today, but in different fields, that's produced by our associate members and our founding members. So lots of content, lots of resource on our website. Check that out. Also, I do want to mention, if you have any nonprofit colleagues that you'd like to introduce us to become a member of the Nonprofit Resource Hub, please reach out to one of our members, Danette O'Connell, or one of our founding board members, and we'll be happy to help them connect and become a member of a nonprofit member of the Nonprofit Resource Hub. You can also enroll as a member on our website. And I would also remind everybody, if you have any partners, vendor partners that you work with that think would be a good set for a good fit for our associate member program, please feel free to reach out to us and make introductions to those as well. And again, our next events will be up and scheduled in the near future. Check out our website to see all those events that are upcoming. And I want to remind everybody of the raffle that is still in play up until December 31st. So any nonprofits that join the Nonprofit Resource Hub between now and December 31st will be input into our raffle, and 5 winners will be drawn, and will be receiving a donation of $200 to their organization. And with that, I just want to thank you all once again for joining us today. We look forward to seeing you in the near future. Everybody stay safe with this impending weather we have and our continued coronavirus pandemic. And I want to wish everybody also a very happy and healthy holiday season. We look forward to a great 2021 and growing the Nonprofit Resource Hub with all of you. So thank you all. Have a great day and look forward to seeing you soon. Bye now.